So, welcome class. Here we are in one of the discussions that I consider Professor Jacobo one of the experts, and I want him to shine light based on these two questions. One of them is look at how California had to challenge the right to citizenship in the famous court case that you read, People versus de la Guerra, and also how Dominga Dominguez lost the right to her land. That's number one. And number two, Professor Jacobo, what can we say about the U.S. immigration policies of that time and the treatment of Mexicanos years after the treaty?
All right, great. So I think, first of all, most scholars will tell you that the most important articles of the Treaty of Guadalupe Hidalgo are Articles 8 and 9 because they dealt primarily with civic and property rights. That is the case in particular with Article 8, where it tells you you can stay in the land where you now reside. You can remove yourself given the fact that there was violence, right? Sort of like a refugee in Mexico if you want, and come back to the property, or to sell it, right? And so those are very important articles 8 and 9. They protect against civic and property rights of the former Mexican nationals in the United States. In the case of civic rights, the hallmark case is definitely People versus de la Guerra, because it tells us when a Mexican national that chose to become a U.S. citizen, when that, if you will, that privilege or that right was executed. It's interesting because the treaty was signed in 1848. California, which was the first state that was carved out of Mexican territory, became a state in 1850. But the rights of Mexican origin people to become U.S. citizens did not take place until 1869, with this particular case, People versus Pablo de la Guerra. So it's an important, again, hallmark case to understand that civic rights in particular. When it comes to the issue of property, it's a bit more complex because there was an article, Article 10, that protected all of the land grants given by the Mexican government and its authorities. And that Article 10 was deleted, if you will, by the Polk administration, and it left then the treaty to interpretation, if you will, about how the rights of property will be executed. In the case of California, you can imagine, as we said earlier, was the first state to be carved out of Mexican territory. There was a lot of competition for land, right, between not just your average, let's say, families or people, but really also corporations. So there were several cases that involved property, but Dominga Dominguez versus Botier, or vice versa, if you will, is the hallmark case. Nowhere in the treaty did it say that the Mexican people had to prove that the land they lived in was theirs, but there was a Land Law Act of 1851 in California that did just that. It demanded that all Mexican people of Mexican descent, now in California, prove the property that they lived in or the property was truly theirs in an American tribunal, if you will. And that was very complex. For some reason, Dominga Dominguez had ample evidence to their property ownership. They have all the documents in order, but did not go within the 2 years allocated by the Land Law Act to prove the property was theirs. Some believe that they did not think they had to do so again because it was never mentioned in the Treaty of Guadalupe Hidalgo. This particular case went all the way from the local courts to the United States Supreme Court. And in the case of the Supreme Court, the Supreme Court of the United States decided that it was to the advantage of the United States to basically ignore, to some extent, the Treaty of Guadalupe Hidalgo, to allow local courts decide what was best in terms of the interpretation of the Treaty of Guadalupe Hidalgo. That, of course, left someone like Dominga Dominguez without any rights or over property, and it set a very dangerous precedent, if you will, for Mexican origin people in terms of their land ownership. Really, what it did was it minimized the value or the importance of the Treaty of Guadalupe Hidalgo. And some experts tell us as well that it actually contradicts the American Constitution, which in several clauses protects international treaties of this caliber. So those are two very important cases again. There's several of them again, but these are the two classic ones, if you will. One dealing mainly with the civic issue and one with the property issue. When it comes to question number two, I think we have to understand the context of the time, the chaos, that there was indeed structural political racism, in effect, and that there was really no clarity on really what was the immigration policy of the United States at the time towards Mexico. and let alone what was really promised to the Mexican origin people in the United States at that time versus, again, what happens, for example, today, where we might have an idea of how to become a resident or a citizen. Back then, it was quite chaotic and really left, in many ways, to the interpretation, again, of the states until 1869. And even then, frankly, we do not know, or we can say without a doubt, I should say, that those rights were not really executed, that they really were not treated as U.S. citizens. They were second-class citizens at best. Any other question, Professor Gomez?
No, this is actually good. I
covered?
just wanted to invite you to, since you have done a lot of work and research on this topic, and I wanted the students to have another insight aside from what they read in the book. But thank you, and I hope the students enjoy this topic that it really relates to a lot of the immigration policy that continues to be a controversy in the U.S.
Oh, definitely. It's a very complex chapter, but I'm sure the scholars got it and happy to help out any way I can. You always help me as well. Thank you so much.
All right.